Okay, everybody, we're back in week 5, and this week we're going to talk about premises liability. So we discussed investigations law, and you know some of the things that can trip you up when you're doing investigations now. And really, this course is a whole lot about, legal cases that have tripped up security managers and others, and the things you can do to avoid their mistakes, our mistakes. So this week we're going to talk about premises liability. There's a lot of definitions we need to go over first, and if you don't have the definitions, it will not make sense to you. So let's just start defining some terms so we know we're all speaking the same language this week. So premises liability in a nutshell means that a property owner may be responsible for any damages arising out of an injury on that person or entity's property. So if I own a piece of property or if I control a piece of property as a business owner, I have certain responsibilities to my guests. And guests is defined very loosely in most of these laws to include customers, to include people that are invited, and in some cases, some that are not invited, depending on what the injury is and what caused it. All states say that owners that occupy a property have to take a reasonable effort to maintain a safe environment. And that's pretty standard. But you'll see from the case law we talk about this week, there is a great variance in the way states look at liability and premises liability especially. But a failure to keep a property safe for visitors results in premises liability, period. And again, visitors can be the invited, can be customers that could be salesmen that come to your door, depending on the layout of your property. So anybody who comes onto your property, you have a certain responsibility for, and you have to take reasonable care to make sure that they are protected. So that's what premises liability is in a nutshell. Let's look at some of the elements of premises liability. Liability takes on several different forms. In its most blatant form, it's a strict liability. That applies to hazards that are just inherently dangerous or apt to cause harm. So if I have a refrigerator and I put it out at the curb to have it hauled away, in my state and in most states, you must secure the door in some fashion. Excuse me. You must, strap it shut, tape it shut securely, tie it. In some way, you have to make sure the door can't be opened. And that really stems from children playing around it and getting inside and getting trapped if they can't get out, right? I mean, it's a hazard. The door is quite heavy. If the thing tipped over, it'd be hard for a small child to get out. That's where that all stems from, right? If I put out that refrigerator to the curb and I don't properly secure it and somebody doesn't come to pick it up and someone gets harmed, I have a strict liability. It's an inherently dangerous thing. If I decide that I want to protect my property and I put razor wire around the edge of it and someone walking down the street slips on the sidewalk a little bit and falls into my razor wire, I have a strict liability. I've put out something that's inherently dangerous and apt to cause harm. Strict liability, right? No real gray area there. But we're going to find out when we talk about premises liability, there's a lot of gray areas. And the whole thing is built on negligence, and we'll go over negligence twice. First, negligence says that the property owner had a duty of care, right? So in some ways, if I own a piece of property, I am responsible for that piece of property, even when it comes to people who I may not invite onto my property. So if I have a salesman that comes up my sidewalk and comes to my door and slips and falls, my homeowner's insurance is going to probably pay for his injuries because I had a duty of care to make sure that the walkway stayed clear from ice and snow. It only really applies, though, when I knew or should have known about the dangerous condition. So if indeed it was 38 degrees when I went to bed at night, and in the morning I get up and it was 29 and ice formed, and I had a very early salesman and they came and I find them lying prone on the sidewalk in front of my home, I didn't know that there was a dangerous condition. Therefore, my negligence, my liability on that is a little bit gray, right? I should have known, maybe. Did I know? Absolutely not. I was asleep. I didn't know the temperature dropped that far. You have time in most cases, right? But if I know about the condition, I have to remedy the condition, okay? So if indeed I got up and it's 29 degrees and I go out and I look outside and I see that things look icy and I don't put some salt down, then I didn't remedy the condition. If it can be proven that I knew about it and in a reasonable amount of time didn't remedy it, then indeed I have some negligence. And that breach of duty had to cause the injury that happened. So if indeed the person slipped and fell on the ice, I knew about the ice and didn't do anything about it, then I have breached my duty as the property owner. It caused an injury, and therefore I am negligent. When it comes to courts and negligence, there are two different schools of thought, if you will. Comparative negligence, where both the owner and the injured have a share in the injury, right? There's a monetary recovery based on each party's share of the fault, and if the injured is more than 50% at fault, there's no relief awarded at all. So if I don't salt that sidewalk and I knew about it, then and the person came up and they were running down the sidewalk, and it can be proven, right? My Ring doorbell camera showed them running down the sidewalk, not paying attention, and they slipped and fall. A court may say that I am 70% at fault because I didn't salt the sidewalk, and they are 30% at fault because they were running in a haphazard manner. If indeed that happens in a judgment, I would be responsible for 70% of that injury. They would be responsible for 30% of that injury. And in an award, there would be a split of monies and or insurance to cover that. Now, in states that have contributory negligence, generally, if that injured person contributed it in any way to the injury, they are not able to get any relief at all. So in the case of the person running haphazardly down the sidewalk, they would not be entitled to anything because they contributed it. Had they been walking carefully, which a normal person would do in the wintertime, where you can potentially see if a sidewalk is icy, right? You take small steps, you walk like a penguin with your feet kind of spread out a little bit, right, so that you don't fall. And if they run, and they should have taken some care themselves, then under contributory negligence states, they're not entitled to anything. So states are either comparative or contributory, and Pennsylvania is a comparative negligence state, just in case you needed to know. So the amount that each party contributes to the injury generally affects the amount of award that someone may or may not receive. If the party that is injured is more than 50% at fault, then no one will be awarded anything for that injury. But in order to move forward with any kind of award as we talk, right? We're talking about lawsuits or insurance payouts, those types of things, settlements. You have to have certain elements for any type of action in premises liability. And those are an injury. You have to be able to show a duty of care, something called foreseeability. There has to be some kind of negligence. Otherwise, there would be no one to sue, if you would. And then there has to be proximate cause, and there's a connection there. So let's go over each one of those individually so you understand those before we get into a couple of cases. So when we talk about an injury, it doesn't have to be a physical injury. That's most common, right? And we've all seen the billboards as we drive down the highway, slip and fall, give us a call. And it has a smiling picture of some attorney on it. Normally, physical injuries are involved when we talk about premises liability. However, it doesn't have to be a physical injury. Let's just say that I am carrying an expensive piece of artwork up a stairway at a commercial building, right? I'm going to go and donate it to the gallery. And as I walk up the stairway, one of the stairs breaks because it hasn't been maintained well. And the piece of artwork I'm carrying drops and is completely ruined and has no value. I've suffered an economic injury. No physical injury. I wasn't harmed, but the piece of expensive artwork I was carrying or whatever else may be damaged would cause an economic injury. That in and of itself is considered an injury for premises liability. Now, there's certainly slip and falls, and those would be a physical injury, so we're aware of those. There can be a psychological injury. So if I have a second-story deck on my house, and let's say I invite my friend over, and the friend is leaning against the railing, and the railing gives way, and this person falls. Now they're not seriously injured, but now they are death afraid of heights, and they can't continue their career as a window washer because they'd have to go up on heights, and they can't do it anymore. They've suffered a psychological injury. They could say that my premises caused that psychological injury. Bit of a stretch, certainly, but many lawsuits are based on psychological injuries, and especially when someone is seeking punitive damages, a punishment type damage. They're looking for that extra money. So the injury doesn't have to be physical. It can be economic. It can be psychological. It can be any type of harm. But any harm or injury can cause you grief as a security manager on your property, especially if it's related to a security type function. So once we have an injury, now we look for the duty of care. Was there any kind of permission to access the property? And it doesn't have to be direct. It doesn't have to be come on in. Again, that salesman who walks up to my front door has come down my driveway and up my sidewalk to my home and may be injured on the way. Unless I have specifically blocked those areas to their access, then there's an implicit permission to access the property if the property is open. So there's any number of reasons a person could be on your property. They could be invited. Could be that you're open for business. So if you're a business and you are open or presumed to be open, right? Someone can access your business. They can open the door and walk in. They're not necessarily invited. You would like to have customers come in, but you haven't specifically invited them. But you're open for business, so they can come in. If you have open access and it's not delineated, again, the salesman comes down the driveway, down the walk, certainly allowed to do that. The access is not delineated. There's no fence yard. There's no sign that says keep out, any of those things, which in some cases may not even be enough in some states and some jurisdictions. Owned or leased property doesn't matter. You may invite it, or it could be the landlord invites somebody. And sometimes your property is managed by someone else. Therefore, they send in someone to mow the lawn. They send in someone to clear the drives. They send in someone to water the plants, whatever it may be. You did not specifically invite them yourself, but the property manager may have, and they are authorized to do so. So a duty of care really is about whether or not a person was on your property and reasonably could have accessed that property and not normally in a criminal way. Although we will see cases where even a criminal has some rights in your home. So duty of care really is, did you control the property in some way, either through a lease or ownership agreement, or you're managing the property for someone or someone's managing for you? Is the person on the property, therefore you have a duty of care to protect them from injury. So the next element of premises liability is something called foreseeability. Stairs are meant for climbing. You wouldn't have stairs normally if they weren't be climbed to get to the next level, right? So you can foresee that stairs will be climbed. If you have stairs, that's foreseeable. They will be climbed. If a stair is broken, you know someone's going to climb the stairs. That's foreseeable. And you may have some liability for the broken stair if they are injured, right? Same condition. Days have sunlight. Days are light out and night does not. So darkness is foreseeable. I can pretty much predict what time of night it's going to get dark at my home. And if I am going to entertain guests, I know that I need to have lights on so that they will not be injured, right? It's foreseeable. Now, is it foreseeable somebody walking around in the dark trying to break in one of my lower level windows at midnight? Do I need to have lights on for them? No, that's questionable. That's certainly questionable. They're not invited. There's no reasonable expectation that they should be where they are. So that's not foreseeable. But for people that I invite or people that could reasonably access my property, certainly darkness is foreseeable, and I'm required to give them some form of light so that they're not injured. Now, weather is foreseeable, right? We all can watch the weather on the news or pop on our cell phones and check to see what the weather's going to be, but it's also transitional and sometimes fickle, right? So weather changes. We always say that the weatherman says there's a 30% chance of snow, but there's only a 20% chance they're right. So what does that really make the chance of snow, right? The 6%, by the way. The idea that weather changes is something that gives you some time to remedy a situation where there may be liability. So again, while snow is coming down sideways, here in the great state of Michigan and in the great state of Pennsylvania, and especially in western Pennsylvania and western Michigan, we get some snowstorms, and oftentimes it is pretty nasty outside. And while the snow is coming down and it's blowing around, you have less liability on your property than after the snow has ended and it's a day later and you still haven't shoveled the walkways, right? You have some time. It's transitional. Now, crime may be foreseeable. If you are in a dangerous part of a town, and there are crime statistics to say that it is dangerous in your part of town, then crime in that part of town or that neighborhood or that area or with that type of business may be foreseeable, and therefore you have certain remedies that you must put in place, certain remediations to protect your duty of care, to protect your guests and others from injury. Now, premeditation negates foreseeability, right? I can't tell if someone is going to premeditate a crime, right? Then I can't foresee that. If that's in somebody's mind, I can't foresee that somebody's going to come on to if someone were to walk into my house while I have guests and come in and shoot the guest, I can't foresee that. That's a premeditated crime. I can foresee perhaps that if I live in a bad neighborhood and they walk outside at night and I don't turn the light on, that they might be harmed, and I may suffer a lawsuit for that. But in general cases, premeditation negates foreseeability. But a security manager has to foresee security hazards. And in fact, the perpetrator of a crime can often testify in a lawsuit on behalf of the victim to tell them why they victimized them, right? Why did you jump me in the parking lot of the ABC store? Well, I did it because the ABC store has terrible lighting. I know they have no cameras, and there's only one guy working inside, and he's half asleep all the time. So it was a great place for me to come and rob you and assault you. In that case, the perpetrator, who in many cases has nothing to lose, they're already jailed, will testify on the behalf of the victim and put your business at risk. So foreseeability is kind of an interesting thing. It is really that crystal ball that you have to look into, but it's a crystal ball with a lot of hints. You know when bad weather is coming. You know that after the bad weather you have to clean up. You know that it's going to get dark at night, so at night you're going to need to light your business. You know if you have stairs, you need to keep them in good repair because stairs were meant for climbing. So when you can foresee something, when it is possible that you could have seen this coming, as they say, then you need to take steps as a security manager to close those vulnerabilities. Now, we just went over negligence, and this is the exact same slide, but I wanted to make sure that you understood negligence is just you have a duty of care to the injured. You knew or should have known about the condition, the dangerous condition. You failed to remedy it, and that breach of duty directly caused the injury. That's what defines negligence. But in the security world, there's some unique things that can be considered to be negligent security. And make no mistake about it, prevalent and lucrative are two words that I kept seeing used when researching negligent security cases. There are some that cite it, although I could not find a definitive reference, as the most collected awards in the U.S. are cases of negligent security. And it kind of makes sense. Someone suffers a harm, they may be killed and their family sues, or they may be seriously injured by a criminal on your property, and you didn't take reasonable care to protect them from that criminal. Now, negligent security is normally considered a passive negligence. Active negligence is when I take an action that hurts you. Right? I did something. In the case of negligent security, it's normally I did not do something. I didn't take an action I should have taken, and that inaction caused the environment for the harm. I didn't repair my lights, and therefore the parking lot was dark, and therefore you were hurt. You as the security manager are the one responsible for negligent security. That's the one you can most influence. Now, slip and fall hazards are a close second to negligent security when it comes to premises liability, but in many ways, some of the things you do for security, like lighting in safe environments and other protective measures, can also guard against slips and falls. But you are in a great position as a security manager to influence cases of negligent security and to remedy those before they start. So what are some examples of negligent security that come back to haunt security managers? Broken locks. If you have a lock on the door, but that lock is broken, someone comes into your business and harms one of your employees, they will likely win an award, a premises liability award for negligent security. Damaged doors, fences, gates, anything that allows an assailant to come onto the property that should have been in place or that you put in place. Let's remember that there is normally not a law that says you need to have a fence around a property, but if you put a fence up, you are required to keep it in good repair. Poor lighting. Very seldom is there a law that says you must light something. But if you have lights, they need to work. Lack of security cameras or security alarms, very, subjective kind of thing. But if indeed the crime in your area especially external to your business, is high, and statistically you know or should have known that, then you should have security cameras or alarms in place. Same with security guards. If indeed you are in an area where everybody else in the neighborhood has security guards and you do not, you should be asking yourself, why do they have them? Why do I not have them? And am I setting myself up for liability? And then inadequate security procedures or poor training on security practices. We'll see that in a case right up front that was actually quite startling when I was reviewing the case. But if you have security guards and you have security procedures, you have to practice them, you have to train people on them, and you have to follow them. Otherwise, they become a liability. And finally, all this comes together in what's called proximate cause, where you need to show that all of the elements came together and the missing thing was what caused the injury. So in proximate cause, did the harm or injury result from the negligence that was cited? So in a case, let's look at two examples. A store has a faulty lock on their rear emergency door. Both cases, right? Case one, a perpetrator comes in through that rear door with the faulty lock on it during normal business hours and stabs a store clerk who's in the back room eating their lunch. Okay? Perpetrator comes in, faulty lock, back room, employee is in there having their lunch. The perpetrator stabs that employee. Example two, the lock on the back door is still bad, same bad door, but the perpetrator comes in through the common front door entrance, the one that all customers come through during normal business hours, walks in behind the curtain that leads to the back room, and stabs the clerk eating lunch in the back room. In both cases, the clerk is equally dead. In both cases, the clerk was stabbed by the same perpetrator. But in example one, there's clear proximate cause. The injury was related to that broken lock because that's how the person got in. In example two, proximate cause is doubtful because anybody could have come through that way. So you look at the exact same crime with the exact same result, but how it was perpetrated, how access was gained in this case, is what created proximate cause or not. And in a premises liability case, the proximate cause in example one, you would be paying out an award to somebody. In a number two, you probably would not. So proximate cause just shows that the injury was related to the negligence. So this week, to tie all this together, we're going to look at three cases. Tolbert v. Gantz and Quality Inn Hotels, a shooting case in South Carolina. Hammer v. Lee Memorial Health System, a sexual assault in a hospital in Florida. And Harris v. Pizza Hut of Louisiana, a shooting at a Pizza Hut restaurant in which a off-duty police officer was being used as a security guard. In all three of these cases, we see how the idea of premises liability plays out in court. So in Tolbert v. Gant and Quality Inn Hotel, Tolbert was a guest at a hotel in South Carolina, and he had a roommate at that hotel. If I'm not mistaken, he was working on a long-term project for an employer, and you'll see that a lot in hotels, especially chain hotels like Quality Inns, where an employer will bring people in for a 30-day project, and for 30 days they will live in the hotel, and they may have a roommate from the company with them and sharing a room. Tolbert came back to his room and found that his roommate had invited in two other guests who he never met before, and they were drinking, and the two guests got into an argument which resulted in each one of them pulling a handgun on the other. So the two of them are in a face-to-face standoff, right, with handguns. Now, Tolbert talked them down, and eventually they put the weapons down. And immediately after that, Tolbert started to leave the room. One of those guests thought Tolbert was now going to go call the police, got nervous, picked up the handgun, walked outside onto the balcony of this walk-up hotel, and shot Tolbert in the leg. Tolbert sued the Quality Inn for failing to protect him from injury. He said that he was indeed a registered guest of the hotel. The hotel had a duty of care to protect him, and they failed in that duty. They were negligent, and therefore he was entitled to some sort of settlement against the hotel. So let's look at a few other matters related to Tolbert and Gant. So Tolbert testified that he saw security cameras, there were hardened door locks, there were police patrols that he saw quite a few in the parking lot while he was staying in the hotel, and he knew that a part-time security guard was on the premises. He had heard that from people, and that was true, that the hotel had taken those measures. They had cameras. They had hardened door locks. The police were in and out of the parking lot on a regular basis because the area does have a high crime rate. Now, the guests were invited by the roommate. The hotel did not register those guests and therefore really didn't have any duty of care to those guests at all, those two uninvited people at all, right? But Tolbert did not contribute to the situation in any way. He only returned to his room. He walked in. These two people started a fight. He talked them down, and then immediately after talking them down, one of them decided it was, Tolbert that should be shot and shot him. So a whole lot of stuff going on here. And really, we have to look at the elements of premises liability one by one and see how they affected Tolbert. So, was there an injury? Yeah, Tolbert was shot. There was definitely a physical injury. How about a duty of care? He was a registered guest, Tolbert was, and he was paying for a safe place. So the hotel did have a duty of care for Tolbert. When you stay at a hotel, there is a duty of care. Now, foreseeability, there was high crime in the area, right? And you could have said that, there's going to be problems at the hotel, right? This is one of those areas where you shouldn't stay in that hotel. But this particular incident, right, an argument and gunplay between visitors who weren't registered guests at all, that was not at all foreseeable by the hotel. The hotel provided adequate security, and Tolbert testified to that, right? We had patrols, hardened locks, cameras, a security guard. About everything the hotel could do to provide security was done. And so the court found that there was no negligence. Therefore, there could be no proximate cause. Remember, proximate cause is was there a duty of care, and did the injury align with the negligence? Was the injury caused in some way because of the negligence? Well, because there was no negligence at all found by the court, there was no proximate cause, and there was no judgment for Tolbert. Tolbert got nothing but shot in the leg. So what do we learn from Tolbert v. Gantz and quality in hotels? Well, the hotel's registered guests, they have an expectation of a safe and secure lodging. They're paying for that. The duty of care is clear to your guests, and hotels have a really unique duty of care. For those of you who go into hospitality security, and there are a lot of great jobs in that field. I have a lot of friends who work in it and do very, very well. Hotels really have a unique duty of care because people are not only paying for a clean, comfortable bed, they're also paying for safety and security of the premises. So the duty of care is even stepped up in places like where you stay overnight, right? The duty of care is stepped up. Now, Tolbert's injury was not at all foreseeable by the owner. They could not foresee that guests would come in to visit Tolbert that he did not invite, and one of them would shoot him. They did provide reasonable security, so no negligence was present. They did what they could do, and since they went above and beyond, quite frankly, where most hotels in bad areas would go, there was no negligence on their part, and therefore proximate cause, the linking of the injury to the negligence, could not be made. But as a security manager, you have to do a thorough risk and threat assessment to understand both your duty of care and foreseeability. In this case, you wouldn't guard against outsiders coming in with a gun, invited into a room and shooting somebody. But you would, knowing that there's crime in the area and knowing that you need to protect your guests, have put in place, just as this hotel did, security guards, hardened locks, cameras, and asked for increased police patrols. They had the foreseeability down. They did their homework, and in this case, it protected them from a premises liability suit, and the hotel did not have to pay out to Tolbert on his injury. So let's look at a case that goes even a little further in this foreseeability. And that is Brianna Hammer versus Lee Memorial Health System and Giovanni Hecheverria, who was a nurse at Lee County Hospital. And I'll call him Giovanni from now on because I'm sure I'm butchering his last name. So Hammer was a patient at Lee Memorial Hospital. She was under heavy sedation, and Giovanni, the nurse, came in and he sexually assaulted her twice in one evening. And the facts of that are not disputed. He indeed was criminally convicted of sexual assault. Hammer alleged that Lee Memorial Hospital provided negligent security because the hospital is in a high crime area. Florida law examined the negligent security claim as one of 4 claims made by Hammer. Now, she claimed negligent hiring, she claimed negligent security, she claimed some other I forget, there were 2 other complaints in that case that were really not related to the security matter, but she had 4 separate claims But in this case, the negligent security claim was based on the hospital being in a high crime area, and therefore they did not offer proper protection to her. They did not exercise proper duty of care by making sure that Giovanni, the nurse, did not sexually assault her. So some interesting quotes from this particular case. And under Florida premises liability principles, right, because each state's a little different, the property owner owes two duties to a business invitee, which Hammer was in this case, right? They need to take ordinary and reasonable care to keep its premises reasonably safe for invitees, and they need to warn of perils that were known or should have been known to the owner and which the invitee could not discover. Okay? So, with those two duties, if they knew that Nurse Giovanni was a sexual predator, then they would have had a duty to warn Miss Hammer that indeed he was, that he'd been accused of it in the past, that he had convictions that should have been noted if that were the case. The duty of care owned by a landowner to an invitee with respect to protection from criminal acts of a third person is dependent upon the foreseeability of that third party's activity. Again, should Lee Memorial Health System have known that this guy was a sexual predator? Hammer was not able to show that Lee County Memorial Health System should have known he was a sexual predator because he had no history of it. They had done a background check. They had hired him based on a clean background check. And the fact that he was a sexual predator or may have just become a sexual predator in this isolated case was not known to the health system. And Hammer was unable to prove foreseeability on behalf of the hospital as to Nurse Giovanni's actions. So let's go down our list of elements here. Hammer was assaulted. She was definitely injured. No question about it. And is there a duty of care? Of course, a hospital has a duty of care that includes security, right? If you're a person in the hospital, you don't want to be the victim of a crime while you're in the hospital. The hospital is taking your money, no different than the hotel in this case, not just for a clean, comfortable room with medical care, but also for safety and security while you're staying in the hospital. But without previous information, even though the hospital is in a high crime area, there's no way that they could have foreseen the actions of that nurse. So the court found negligence and foreseeability to be absolutely linked here, but there was no negligent security. Since there was no proven negligence, there was no proximate cause. Again, we have an injury, we have a duty of care. We don't have foreseeability because, again, there was nothing in this person's history, this nurse's history, that said they were a sexual predator. Therefore, there was no negligence on behalf of the hospital because even though they had a duty to warn, they can only warn on things they know, and therefore there's no proximate cause, and Hammer was not awarded a judgment against the hospital in this matter. So what do we learn in this? As a security manager, I think some of the things we learn are what could have happened. Sometimes that's the best lesson. So foreseeability is a major factor in negligent security cases. Could you have seen this coming? Would a reasonable person have done something differently? You should have known this was going to happen. And a duty of care includes forewarning guests and visitors of potential hazards, right? Premises liability cases, people slip and fall on floors. And sometimes if you have a sign out that says wet floor, we've all seen those little yellow tent signs, that's enough to warn somebody of a potential hazard. And you have a duty to do that. But what if that nurse had a criminal history of sexual assault? What about if others had made complaints in the past? What if the hospital was in the process of investigating other claims against this person for sexual misconduct in the hospital with patients? In that case, you had a couple of options. Number one, I would have suspended the nurse until the investigation was complete, because then they would have no access to patients. But even if you didn't do that, you had a duty in Florida to warn that person that they should not be alone with any nurses. Right? There should always be a witness in the room anytime medical care is given, right? Patients should never be with just one caregiver in that case. So think about what policies you might want to add when you're a security manager to think about the fact that this could have gone horribly wrong if there was anything that the hospital had known about the nurse. It could have went horribly wrong. And as a security manager, you might want to have policies that say, well, when a security officer is interviewing somebody, it's going to be done in a room with a witness, right? So that there's no blowback to you, right? I mean, there's a lot of things you can learn, even though the case didn't go against the property owner. I think this hospital would, in this case, have made policy changes to say that nurses, male nurses especially, with female patients, although it could go either way, or with minors, certainly any vulnerable population, a person under sedation maybe is the better way to put it, right? Let's not make it gender-based. Let's make it based on vulnerability. Any patient who has had any kind of sedation must have two caregivers in the room with them whenever treatment is administered. Even though they didn't lose, there's a lot of things you can learn from these cases to make your policies a little more airtight and keep yourself away from lawsuits, which is really the goal here. This last one didn't go as planned for the business, and it is something that is directly security related and something that could certainly happen to anybody who goes into this field. Miss Harris and her daughter were patrons of a Pizza Hut in New Orleans, and that particular restaurant was really in a bad area of New Orleans. If you spent any time in New Orleans, and I have, there are some areas that are really crime-ridden, is the only way to say it, right? The restaurant had been subject to armed robberies and burglaries 20 times in the previous year. The owners, in an effort to try to, put things in place, their duty of care, they hired off-duty New Orleans Police Department officers as uniformed security. They wore their police uniforms. They were paid by the restaurant as armed security. And when they did that, the robbery slowed down, right? People saw the police officers on the premises, and they just said, I'm not going in and rob the Pizza Hut. There's an armed cop in there. Maxie Walker, who was an off-duty NOPD officer, was on duty as a security officer on the night in question, the night that Miss Harris and her daughter came in for dinner. Walker came in to work and immediately took a dinner break himself and sat down in the dining area eating a salad and talking to one of the restaurant employees sitting at a table. A couple of armed robbers entered and firing commenced. There's some discussion in the case and some ambiguity about who fired the first shot. But certainly a gunfight ensued between Walker and the armed robbers, and Harris was caught in the crossfire. She was killed, and her daughter was injured in the crossfire. Walker killed one of the robbers, wounded the other. He was shot, but he survived. So if we go down our list of elements in a premises liability, was there an injury? Yes, Harris was killed. Her daughter was injured. Certainly an injury. Was there a duty of care? Well, by hiring the off-duty police officers, Pizza Hut kind of assumed an enhanced duty of care, right? The court quoted another case specifically and said a duty of care which has been voluntarily assumed must be performed with due care. And this is what's really important to us, in that when you put a security function, be it a person, a device, some kind of enhancement in place, once you voluntarily put it in place, you have to make sure that it stays in good condition and it's performed with due care. Now, was there foreseeability? Past armed robberies made the acts foreseeable. They did react by hiring security, right? And arming security is acknowledging that gunfire might be a result, right? But there's some foreseeability. When you bring someone in that's armed, you could reasonably said that you could foresee that there would be a shot fired, right? You brought in the armed person. So there was foreseeability in this case. There were previous robberies, and we had brought in someone who was armed, so we could foresee that potentially there could be gunplay. Otherwise, we wouldn't have brought an armed person in. The negligence really came, though, because Walker was on dinner break, but he was visible in the dining room. And the question became, was he a patron? Was he on break and not in his official capacity? Or was he an armed security person provided by the restaurant while he was sitting having his dinner? It was found that because he was not in proper work position, right, and him being armed drew the assailants to him, right? When they came in, they looked around the corner, there's a cop that's armed. They went right over to him, one of them did, to make sure the cop stayed in check, and that's what started the gunfire, right? There was a proximate cause between the injury, the duty of care that Pizza Hut brought in on their own volition of bringing in an armed person. They could foresee bringing an armed person on that there would potentially be gunplay. And because Walker was not in his position as a security officer outside of the restaurant perhaps, or in a more visible place, the robbers came in. Had he been visible, had he been in his proper position, not sitting at a table having dinner, the court found that the robbers probably would not have hit the restaurant. And therefore, there was a proximate cause between the injury, the duty of care, foreseeability, and negligence in this case. And the plaintiffs, Harris's survivors, prevailed. They were paid approximately $60,000 each. Her children, she had, I think, 7 children. The daughter was paid $80,000. It was not a huge settlement, actually, for the death of a person, in my opinion. But nonetheless, Pizza Hut paid out because they put security in place, but then didn't train him properly to say, you don't sit in the restaurant having dinner in the corner. You need to be here or there to deter theft or deter robberies. So what do we learn as a security manager in this case? Pretty good things to learn. Armed guards, they're a double-edged sword. An armed guard may deter crime, but they create a liability when they react and use their weapon in that crime or to deter that crime. So think of it this way. If you don't need an armed guard, then don't hire an armed guard. I know security managers, especially those who come out of law enforcement backgrounds or military backgrounds, tend to want to hire armed guards all the time. Armed guards are better than unarmed guards, and that is not necessarily the case. It really depends on what the guard is there for. If you don't need an armed guard, then you don't want an armed guard because not only does it potentially increase your security, but it also potentially increases your liability. We found that with this case that Walker was in the place, but he really wasn't in place, right? Just because you had an armed guard doesn't mean he was in the right place doing the right thing, and therefore he became a liability. Anything you use to show a duty of care creates a duty to provide that element with due care. So when you add security features, be it people like a guard, or lighting, or fencing, or alarms, or code blue boxes, right? Those things in the parking lot that you run up to and hit, and it lights up the blue light and says there's an emergency, and it sends the cavalry. Anytime you add those things, you must make sure that they are in good repair, that they're in working order, because if not, you have added the duty of care. You've admitted to your duty of care, and then you didn't provide it. So non-functioning cameras, safe rooms, duress alarms all present approximate cause to any harm that might ensue from their inoperability. You have to make sure that anything you put in place operates properly. So this week's takeaway really is about premises liability and the duty of care that you have when you are the property controller. You automatically have a duty of care. Sometimes you can go overboard and you can make your duty of care even a higher standard because you have taken on adding things. So you have to be very judicious about adding security features. There has to be some foreseeability, which really should be the thing that helps you decide what security you add. And then there needs to be, and if you can avoid the negligence, you don't have to worry about proximate cause, right? If you can clear up the negligence through the proper devices and proper people and proper procedures in place, you should be set. And you can avoid premises liabilities and lawsuits that come about because of it. So this week you had the lecture. You're done. There is some reading. And there's a quiz. The quiz is due Sunday at 11:59. Just a quick word about quizzes and discussions going forward. There will be no late work accepted unless you have checked with me before the due date of the assignment. And those who contact me 10 minutes before the due date to tell me that they're sick or that you were not sick 10 minutes before a discussion that takes you a half hour to write, I'm not going to buy that. So please, if indeed you can't do an assignment for a valid reason, then you need to contact me before that assignment is due. If not, you will accept a 0 for that week, and that's the policy going forward, and it matches up really with what's said in the syllabus. This week, you should receive some communication from your team leader. In week 14, we will have Zoom meetings that you will schedule, your team will schedule, you'll set the time. They'll last for about an hour. I will give each team scenarios, workplace incidents, and you will go over the potential case laws that might help you make decisions as a security manager to work yourself through those scenarios. So your team leaders will be reaching out to you sometime this week, and please work with them quickly to get a time where everybody on the team can be available for 1 hour. I will not be working my day job in week 14, so I'm going to be available to you. So you guys, if you want to schedule it in the middle of the night, I don't care. But get back with your team leaders quickly because they will be scheduling those meetings and you will need to attend. That particular exercise is 15 points of the 100 available in the course, so it is the biggest amount of points in one single exercise, so you'll definitely want to make that. With that, have a great week. If you need me, you know how to contact me. Again, if it's late work, contact me early because I can't accept any excuses that happen after the due date of the work. So with that, have a great week, and I will see you on campus.